Welcome to the Capital Forum's 6th annual Antitrust Thought Leaders Interview Series, sponsored by KL Discovery. I'm Jeff Bliss, and I'm sitting today with Arthur Burke of Davis Polk. And I'll just describe Arthur as, in my mind, as one of the wise men and women of antitrust, somebody who I think has been quietly effective and forceful in terms of his advocating for his clients' interests over the years. And welcome, and thank you so much for joining me, Art.
Thanks. I appreciate the opportunity to chat.
All right. Well, I wanted to talk a little bit about, because there's a lot of buzz this year about different populist forces outside of the antitrust world, coming from the right and left, really pushing on the antitrust community to become more aggressive. And recently, Bruce Hoffman, who's the acting bureau director of the Bureau of Competition over the FTC, made some comments that about remedies that sounded suspiciously like what DOJ's antitrust chief Macon Delorme has said about remedies. They don't like the behavioral remedies. They don't want to be regulators. They want a clean divestiture, whole standalone business unit if possible. And I'm wondering, is this something new that we're hearing? Is this making it harder for your clients, or do you think that this is kind of more of the same?
So I think I would separate the issues of populism and pressures for change on antitrust from the question of behavioral remedies, because I don't think they're necessarily or logically linked necessarily to each other. So focusing on I think the second part of your question, which is behavioral remedies, right. I think we have to emphasize a few points that put it in context. First, I think the preference has always been stated by the antitrust authorities for a preference toward structural relief rather than behavioral remedies, for all the reasons that the current enforcement heads have identified, that there are enforcement issues that may arise, there are questions of whether the incentives are adequately remedied, there's questions of duration. All of those issues have always been present. So that's one point. I think another point is it isn't as if these things were that common. I mean, it wasn't like there were dozens of behavioral consent decrees every year. They tended to occur, once every few years, and they tended to be concentrated in particular industries, media and telecom, most frequently also certain technology industries. So these were not necessarily that prevalent. So I think stepping back from that, I think this is kind of a tweak around the margins of antitrust. I don't view it as an enormous sea change. 95% of antitrust in the merger context is about horizontal mergers, and that it's going to remain that. And that's the area where the vast majority of enforcement activity always has been focused and will continue to be focused. And I guess one last thing I'll say is, it's interesting. In counseling clients who might be considering a vertical merger, what does this mean for you? In a world where behavioral remedies are more prevalent, a client might take some comfort from that, because they would think, well, look, if I run into a problem, there's a fix that I can enter into that I might find palatable, more palatable than a structural remedy. So in that respect, kind of getting a preference away from behavioral remedies might be problematic for clients. On the other hand, it may reflect also less enforcement overall with respect to vertical mergers. There's two different ways you can get rid of behavioral remedies. You can either start challenging more vertical mergers and insisting upon structural relief, right, or you can have fewer challenges in the first place, in which case you don't need behavioral remedies in any event.
Right. So then I think that's when people are when they're talking about this focus and criticism of behavioral remedies, there are people who are like, well, does that mean that there won't be any remedy at all? That could be a possibility, right?
Yeah, I mean, I think what you could certainly, and it's certainly these are early days of the current administration, but one could imagine a world where, again, behavioral remedies become less prevalent, not necessarily because there's more challenges to vertical mergers, but because there's fewer challenges to vertical mergers, and that therefore there's less of a need for those kinds of those kind of behavioral remedies. But again, time will tell on that front.
Well, you were bringing up vertical mergers, and for so long, since I've been covering this, and certainly before this, vertical mergers, it was an assumption of a pro-competitive effect, marginalization, and so on and so forth. There's some very good reasons and efficiencies, and it's very obvious in a lot of these vertical cases. Do you think that there's a little less of an assumption now? I mean, do you get that sense? Is it just on the margins, or do you think there's like a substantial, like you have to tell people who are vertically merging that like,
You know, it's a great question, and I think the economics hasn't fundamentally changed.
Right.
I mean, yesterday, Carl Shapiro was testifying in connection with the AT&T Time Warner Inc. transaction on behalf of the government, and I think his model acknowledges that there is a pro-competitive effect of that merger, that there is a positive effect from the elimination of double marginalization.
Exactly, yeah.
But his model determines that the anti-competitive effects outweigh that pro-competitive benefit. So the framework, I don't think, has fundamentally changed. And again, people on both sides of the debate frequently agree on those points. It's really the question about what are the data inputs that are going to drive the actual results of a model like that.
Okay, I want to come back at the end towards the populist stuff that we had kind of talked a little bit at the beginning, but I want to go off the merger stuff, and I wanted to ask you about one thing that Bruce Hoffman said earlier this week at a speech. He said, essentially, if any of you people in the audience know of any problems with conduct, questionable conduct out there, please give me a call. And so I'm wondering, do you think that this will be an administration that does more Section 2 investigations? Do you expect that?
Well, look, I think that the people that are running the agencies want to be antitrust enforcers. And so they're looking for cases that are meritorious cases to bring. Now, at the end of the day, there's only so much control they have of that. You actually need facts and you need law to build a case. So time will tell whether, in fact, the right case it presents itself to them. But I'm confident that the folks who are running these agencies, if presented with a meritorious case, would eagerly pursue it. So that's the real question as to what facts come to their attention. Section 2 cases are very hard to bring. Getting the right
Can you
section.
explain? I mean, I've heard that a million times, and I think we've even talked about this before, but can I explain for our audience why they are so hard?
Well, again, first off, even the possession of a monopoly is not unlawful.
Right.
And I think that actually ties back, and we'll talk about it a little bit more, into the populism, because I think a lot of the populist issues that have been raised have been more about just the existence of monopolies, that some companies are just too big. But the law couldn't be clearer that the possession of a monopoly is not by itself unlawful, that in fact it may often be the byproduct of pro-competitive competition. Once there were a bunch of different search engines. There was Lycos, there was Alta Vista, there was Yahoo, et cetera. I don't think anyone has concluded or believes that Google acquired its monopoly or market position. I won't necessarily say whether it's monopoly or not, but it acquired its market position by unlawfully excluding those companies. It had the better product. So that's point number one. Even if you can establish that a company has that kind of dominant position, it's very hard under U.S. law you then have to prove some exclusionary conduct, that the position was acquired or maintained unlawfully. And it's just difficult to meet those parameters, I think. And that's why we've seen so few Section 2 cases over the years. They tend to be once a generation.
All right, well, I know that you don't practice in Europe, but I want to ask you, you raised an interesting question. Under U.S. law, it is not illegal to be a monopoly, but correct me if I'm wrong, I think under EU law, that is a problem.
I think you can have a concept of abuse of a dominant position where it is not, I don't think it's a basis to break up a company, but it may be a situation where a company can be held liable for using its dominant position in an unlawful way by potentially even charging prices that are quote unquote too high. There's plainly no kind of concept like that, I think, under US law.
Well, what I kind of use that as a preface to wonder, because people have been talking about, like, obviously there's an attempt, at least convergence between the EU and US jurisdictions to try to, and it's helpful to companies obviously to have a little bit of similarity there. And I'm wondering, you as a practitioner, have you found that they are converging more now than ever, or are you still seeing perhaps in ways that are not helpful to your client, that it's a problem, that they're kind of doing two different things?
I don't feel like I sense a greater divergence doctrinally. The thing that's as worrisome as doctrinal divergence is process, because actually process can drive outcomes. What's different in Europe than in the US is that the European Commission has to make a reasoned decision that can actually be challenged by deal opponents. Whereas in the U.S. authorities really have their prosecutors, and there's really no oversight that a private party can bring to second guess a no prosecution decision by a U.S. authority. So that's a process difference, but I think it does change the way the European Commission reviews mergers and other conduct. And there's also different timelines, obviously. And as we get into a global antitrust world where there are many enforcement authorities beyond the U.S. and Europe, that multiplies the potential for different processes, different standards of evidence, different standards of review to drive different outcomes.
When I wanted to ask you about that, just to stay on kind of this international topic, is like, for example, Bayer Monsanto, my understanding is it had to be notified in at least 30 jurisdictions, which is a heck of a lot, and there's still obviously going on. Is that also another thing? It's like, it's great that antitrust is spread across the world, all wonderful, but even if you had that convergence, like you said, which again, we're not there, and maybe you never will be, you have all these different deadlines. Is that just like when you're managing these big deals, does that become like another worry for you guys?
Of course, and it is. Now look, even if you've got 30 jurisdictions, it's not likely that all 30 are equally relevant or are equally kind of gating items to the transaction, but they all have to be managed. They're all sovereign countries that have to be respected, and their authorities have to be dealt with. And it's quite a logistical undertaking, and I think that inevitably it leads to longer time horizons for transactions. It's not really a good thing for international commerce, but I'm not sure that there's an obvious solution. Again, these are each sovereign countries, and they want to be able to enforce their own laws and consider the impacts of these transactions on their own citizens.
That makes sense. Well, we've kind of referred to it. I'd like to end with this idea of this, again, populist sentiment that we're seeing from both the left and right. Let's be more aggressive on antitrust in several different ways. Do you see it having an influence right now, and do you see that this is something that we might see for an extended period of time, or is this just a flash in the pan?
So it's a great question, and it's interesting and kind of fun as an antitrust practitioner to have antitrust in the headlines and have people talking about it and interested in it, when frequently people don't even exactly understand what it is that we do. So I think it's great that there's a dialogue about the proper role of antitrust, and it's an interesting time to be part of that debate. I know you were referring to Bruce Hoffman's speech the other day, and I think he also alluded to this.
Yes.
And an example he gave was some calls for consideration of the impact of mergers on jobs. And so there has been a suggestion, well, what if mergers frequently have synergies associated with them, which translate often into job losses. And that's actually often cited as a benefit by merging parties, that they're going to be able to do the same thing with fewer people. That's called efficiencies. That improves the overall economy, even if it might harm the people who lose their jobs. So there's been a call that should be part of the merger review. And I think Mr. Hoffman's point was, that's really not part of the law. That there's really no doctrinal basis, I don't think, to do that. Now, one thing that you can consider is, does the merger affect labor markets, such that the parties might be competing to hire personnel, and the elimination of that competition might create a kind of buying power, monopsony. Now that's something that does fit more within antitrust doctrine, and is something that I think is a legitimate subject of review. But if you wanted to take it from those two examples and push antitrust into looking at things like job loss, like income inequality, like accumulations of power that are not the result of exclusionary conduct, but which are still seen by some as troubling because they are accumulations of power in and of themselves, I think that's very hard to reconcile that with the existing antitrust law that's evolved over the last 100 years. And I think there have been some suggestions by some proponents of this for legislative change, and I think it would take that to really move the needle in a material way, because the doctrine is fairly well established, and there's a consensus amongst antitrust practitioners of both sort of a liberal and conservative bent that while there's a sort of room for debate, things like considering job losses, things like considering just accumulations of power independent of exclusionary conduct are really not within the confines of antitrust, and it's asking too much of antitrust to solve all the other woes of the world. We have a sort of relatively narrow mandate, and antitrust has worked pretty well at achieving the objectives of antitrust. To ask it to do more and to solve income inequality may be asking too much.
Right. Well, Art, as always, it's a pleasure to talk to you, and thank you so much for spending time with us.
Thank you for taking the time to chat. I enjoyed it.